Is there a video of it?
We'll get our hands on it.
Okay, I'm sure they'll turn that over. I'm sure they'll turn that over to you guys. Obviously, I'm assuming they want to see that before their client makes a final decision on that issue. And I'm sure the state will. I'm sure they got people working on that, if I had to assume.
6 in Spanish.
Okay, so but
In
not
Spanish,
just the
you
emails,
would
but
say,
a copy of the video is going to be turned over to the state, to the defense.
Sending her an email as of course.
Okay. Mr. Davis, you said you wanted to. Guys, we got to keep the noise down in the courtroom. If you got to talk to somebody, please go outside the courtroom. I'm still in session. Mr. Davis, you said you want to address any motions now at the end of the state's case this morning. You want to do that now?
1 second, please.
Can you hear me okay, Your Honor?
Yeah.
Thank you. Judge, at this time, the defense would move for a judgment of acquittal, specifically as to counts 1 and 2. To start with, the state cannot prove a crime was committed without the statements of the defendant. Specifically, they cannot prove that it was premeditated or whether or not it was a heat of the moment or a crime of passion. They cannot prove where the crime actually committed, specifically that the elements of the crime, that IS and her unborn child are dead, that the death was caused by a criminal act of Johnatha Quiles, and that the act was premeditated without the defendant's wire statement or wire recorded statements that were on the by the jailhouse snitch. The detective, Billy Abbott, repeatedly stated when he was on the stand on cross-examination that the case turned from a missing person case to that of a homicide case based on the confession and the wire on the defendant. The alleged crime scene at Ace Pick-Apart is based solely upon the confession and the wire of the defendant. And that Detective Abbott specifically stated they could not prove premeditation of murder of IS and the unborn child until they had the confession and that was on the wire. Without Johnatha Quiles' statements on the wire, the state cannot show that a murder has occurred, that there was in fact a crime scene at Ace Pick-Apart, and that he had allegedly lured IS up there to a remote area of Ace Pick-Apart and ultimately murdered IS. All of that is based on, Your Honor, corpus delicti. Specifically, the state's entire case hinges and is based on specifically Billy Abbott's testimony stating that it's either the confession on the wire or his statements to his brother. As such, Your Honor, the defense would rely on, and I'm pulling it back up, forgive me, Judge, I got to pull up my case sites. I had everything pulled up, Judge, and I got kicked off the internet with where I had everything saved.
What's up, big dog?
Pull this up real quick on yours. Mine won't do it. Or there was the JJ. Judge, I need 1 second because I lost this.
Okay, I do have a jury waiting on me.
Specifically, Judge,
Okay.
the state's
Oh,
entire
bro.
case hinges on and is
Oh,
based
bro.
on Jonathan Quiles' statements, either on the wire or the confession to his brother. Based on this, in Williams v. State, 689 Southern 2nd, 393, and that is a Florida 3rd DCA case, 1997, and Burks v. State, 613 Southern 2nd, 441, specifically citing to page 443. That's a Florida Supreme Court case out of 1993. And it specifically goes into the state may offer into evidence admissions against interest to establish one or more of the elements as charged, but they must have independently established corpus delicti to prove that the defendant actually committed the crime and or that there was a crime scene to corroborate the state's version of the facts. In this case, Judge, there is no blood, there is no body, there is no murder weapon, there is no DNA, and only the wire and the confession to his brother tie Jonathan Quiles to this case specifically. Detective Billy Abbott specifically stated that without the defendant's statements, they could not approve this case. Judge, without that, there is no corpus delicti in this case, and as such, counts 1 and 2 specifically should be dismissed.
What?
Going to count 3.
Can I stop you there? What was the case you cited?
I have 2, Your Honor. The first is Williams v. State, 689 Southern 2nd, 393. That is a Florida 3rd DCA case, 1997. The second case, Your Honor, is Burks v. State, 613 Southern 2nd, 441, citing specifically to page 443. That's a Florida Supreme Court case from 1993, Your Honor.
Okay, go on to count 3 then.
As to count 3, Your Honor, that is based on completely circumstantial evidence of the fact that there may or may not be the defendant's DNA on the pair of panties. The FDLE expert said that his DNA was present, but could not definitively say whether it was a skin cell transfer or whether it was a serology transfer or semen. He said based on his, the testing that he had, there was no definitive either way. Again, without the defendant's statements, saying specifically on the wire that he had sexual intercourse with the two daughters, or excuse me, two nieces, that the state cannot meet their burden and prove their case. Again, that is corpus delicti, and I would cite the same two cases and ask to take that under consideration for the defendant's judgment of acquittal, Your Honor.
Anything else?
No, sir, Your Honor.
State?
Request to remain seated, Your Honor.
Sure.
Your Honor, the state of Florida would ask you to deny the judgment of acquittal. There is a line of cases. I'm going to cite something more recent than counsel has. Mackerley v. State, Mackerley v. State. It is a 4th DCA case from March 22 of 2000. 25 Florida Law Weekly D as in dog 722 stands for the proposition that circumstantial evidence was sufficient to establish corpus delicti for murder, even though the victim's body was never found. And then it goes on, a lot of facts, just like we have in our case. In that particular case, Judge, under the corpus delicti portion of the opinion, just to make sure the record's clear, there are 2 paragraphs that are posted note, and it reads as follows. They were basically the situation judges, they didn't object at trial regarding with respect to either nor argue it at a judgment of acquittal. The appellate court said even if they had preserved the issue, they went on to say this. Even if they have the issue preserved, we would conclude the state of Florida proved the corpus delicti of the murder before Mackerley's confession was admitted.
Oh, yeah.
Murder cases in which the body of the victim is never found frequently invoke questions concerning whether the corpus delicti of the crime had been established prior to the introduction of a confession or admission. It cites Myers v. State, 704, Southern 2nd, 1368, Florida Supreme Court case of 1997. Also Bassett, 2 S's and 2 T's, v. State, 449, Southern 2nd, 803. Florida Supreme Court case out of 1984. It goes on the state, as the 5th DCA aptly pointed out in Lindsay, State v. Lindsay, Lindsey, 738 Southern 2nd, 974. That case reads as follows. The term corpus delicti does not mean dead body, but is more properly defined as the body, foundation, and substance of the crime. The Florida Supreme Court has embraced a 3-part test to establish the corpus delicti for murder. Fact of death, criminal agency of another person as the cause thereof, and the identity of the deceased. Improving corpus delicti circumstantial evidence is sufficient, and proof beyond a reasonable doubt is not necessary. Again, we're talking about at the JOA at the objective stage. Obviously, we need to prove it to this jury beyond a reasonable doubt. And they cite in that particular opinion, SOCOR v. State, SOCHOR. State 619 Southern 2nd 285, Florida Supreme Court case out of 1993. In this particular case that I'm citing for the court, it reads as follows. Mackerley contends that the state failed to establish a corpus delicti of homicide because the state did not demonstrate that, they named the victim, was dead, and that his death was the result of the criminal agency of another. And considering this argument, it is important to note, to establish a corpus delicti, the state is not obligated to prove the specific manner in which the victim died, nor the identity of the person who committed the homicide. Burks v. State, 613, Southern 2nd, 441, Florida Supreme Court case out of 1993. The state need only present some direct or circumstantial evidence tending to show that the victim is dead and the death is a result of criminal activity. Once the state has presented prima facie evidence of the corpus delicti, the state may then introduce the confession or admission against interest to show that the defendant is a perpetrator. In this case, before the court, Your Honor, the defendant, it's not just this wire. There are a load of Snapchat messages from the defendant to the victim that this jury listened to that showed this ongoing relationship and this how enraged the defendant got. All those statements are they're not on the wire. They're confirmed by the wire. But all those Snapchat statements, Your Honor, were establishing sort of a relationship, establishing this was the only person she was in this relationship with. They were establishing that this is who Jose was. They were establishing that the victim herself, IS herself, Your Honor, was trying to leave him. They established numerous things before we even ever get to the wire. Furthermore, the evidence very clearly shows them meeting up. He turns his geolocation data off at the same time she's leaving Terry Parker High School. Haley Schimpert testified she saw him pick her up. That's connecting them. That's putting them together. That's showing that when she disappears, she's with him. All this evidence that we put forth showing that she no longer exists, her bank statement, family, her last work at Chick-fil-A. She didn't even pick up her checks. We established she did not exist on the face of this earth. We established that when she disappeared, it appeared to be she's walking off school grounds, never to be seen again by family, by friends, by phone. Her phone goes off. All the things that we're able to show to establish she's deceased. This is foul play. This is nothing she did consensually. And here we are 4 years later, she's and she's never to be seen again. The state not only establishes that, but absent any wire, the state also shows in corroboration of the wire prior to the wire ever even happening. He's telling his brother. He's giving his brother, he calls his brother and confesses, which again, as the court knows, we put all three of those confession witnesses on at the very end of our case, having established all these other facts that show this is foul play. She's gone, she disappeared off the face of the earth. The case law supports the proposition that circumstantial evidence does warrant proving corpus delicti. In this case, to answer that proposition, we'd ask the court deny, and for the same arguments with respect to the sexual battery, deny the JOA with respect to counts 1, 2, and 3.
Counsel, how do you spell Mackerley again?
Mackerley.
That was March of 22.
Yes, sir. March 22 of 2000.
I'm sorry, I misunderstood you.
Yes, sir.
I think is it a 4th ECA?
Yes, sir.
Okay, I found the site. The March date threw me off. It's actually, I think the main date came down on April 2nd. The case is 294 Southern 3rd 311, 4th ECA. I'm sorry, that's not the case. My apologies.
I can give the court my copy. I've got a hard copy as well.
Oh, it's okay. I'll find it.
If I may, Judge, just briefly,
Oh, yes, sir, of course.
in Burks v. State, I agree with everything that the state said, except the state has the burden of proving by substantial evidence, and this is a quote in Burks, that the state has the burden of proving by substantial evidence that a crime was committed, and such proof may be in the form of circumstantial evidence, but it cannot be just mere evidence to show that a crime is committed, and it need not be proven beyond a reasonable doubt. But in this case, specifically to differentiate, Billy Abbott specifically said that without the defendant's own statements on the wire, he had no knowledge that a crime had been committed and that she was dead. As such, he admitted there was no blood, no body. He couldn't confirm as to what was the murder weapon, and there was no DNA found other than on the panties, and he couldn't say if that was in the commission of a sex crime or not. And then he based everything solely on the wire and the confession of the defendant to his brother. That, Your Honor, is failing to meet the grounds for corpus delicti.
Said March 22nd, 2000.
Yes, sir.
Site 754, Southern 2nd, 132. That decision looks like it was squashed by the Supreme Court. It looks like it was a wholly separate issue, though.
Yes, sir. And
Court opinion.
if you go to that third,
Yeah, let me get the site on the record, Mr. Tanner. The site for the Supreme Court case is 777, Southern 2nd, 969. Looks like the issue on appeal was a general verdict for first degree murder on dual theories of premeditation and murder. That was the issue on appeal that was certified by the Supreme Court. I want to make sure, even it's red flagged in Westlaw, to see a red flag, your eyes perk up a little bit. But it looks like the issue that was addressed is a separate issue than what's being discussed here in court today regarding the JOA issue. So I just want to make that clear. So it's not an issue on appeal.
Yes, sir. Thank you. And the reason we're citing it is because it lays out that line of cases that stand for the proposition that is good law. I cited Bassett and Myers and Lindsay and SOCOR, SOCHOR, Drysdale, all the cases that I read when I was going through the body, stand for the proposition that even the defense agrees is good law.
I do.
The light most favorable to the state, the JOA is denied. Can you bring the jury back in now?
And while we're doing that, we just need to change out 33B. There was an issue with the disc when we had put it in, and we have a new one that actually works properly. It is the second part of the defendant's cell phone number.
Defense?
Sorry.
State's asking to replace 33B with a working CD.
No objection.
Okay, you go ahead and take
That's
care
all
of that.
we need.
At this point, what I'm probably going to do is not give the jury a mid-morning break. I'll go straight to a lunch hour, take an earlier lunch, and see where we're at.
What?
One moment, Your Honor.
Don't start, Judge.
I agree. Judge, for purposes of, rather than stopping, taking the jury out, do you want to inquire of our client now as to whether or not he wishes to testify?
Does the evidence that the state mentioned this morning change that analysis at all? That's why I was going to wait. But if it's not changing the analysis,
They've had a chance to talk to me, Your Honor. We prefer court require now, and then they could, once they put on, I think they're putting on 3 witnesses, and they could rest.
I want him to testify. I want him to take the stand.
Sir Quiles, can you raise your right hand, please? Do you swear or affirm, tell the truth, the whole truth, nothing but the truth? All right, sir.
Oh, he gonna
We're at
take
the
the
stage of the ball game now where the state's rested their case in chief, and now I turn to the defense. Obviously, as you heard me tell the jury during jury selection and throughout the trial, the
What?
state of Florida bears the burden to prove the case beyond a reasonable doubt. The defense does not have to do anything, does not have to call any witnesses, etc. You have an absolute right to remain silent, and I'm going to talk to you about that. You have a constitutional right to remain silent. If you decide not to testify, the court will instruct the jury that the fact that you do not testify is not to be considered by them in any way whatsoever in their deliberations. And if you recall, we talked about that in jury selection, and I gave an example of that. If you choose to testify, the court will instruct the jury that the testimony is to be considered like the testimony of any other witness. If you testify, the state will cross-examine you and ask you, if applicable, if you are a convicted felon, and if so, how many times. My understanding is that you are not a convicted felon and do not have any convictions for crimes of dishonesty. So the state is not able to ask you that question because they don't have a good faith basis to ask you that question. Is that correct, defense? State.
Yes, sir.
I don't even know. I don't know what he's talking about.
As you saw throughout the trial, a couple times it was mentioned, are you a convicted felon? If so, how many times? That line of questions will not be able to be asked of you because it's not pertinent to your testimony since you do not meet that criteria. The right to remain silent belongs to you and to you alone, not to anyone else, including your attorneys. Your attorneys can give you advice and their opinion, but the decision whether to testify or remain silent belongs only to you. Have you discussed all of this with your lawyer?
I have.
You need more time to do so.
There you go. Take the
And what is
stand.
it? And what decision have you made regarding testifying?
I'm not going to testify.
What?
Is this decision being made voluntarily?
Yes.
Has anyone forced you to make this decision?
Man.
Coerced you?
Nope.
Pressured you?
No, sir.
Threatened you in any way whatsoever?
No.
Oh,
You've
he-
had ample time to talk to your attorney about this decision?
Yes.
You seem rather confident in the decision.
Yes.
Is there any inquiry you want me to make addition to that regarding his decision not to testify at defense? Correct. Okay, so I'm putting aside the decision not to testify. I'm going to move over to another line of questionings. But there's nothing else you want me to inquire about specific regarding his decision not to testify. Okay, so the court is making a finding that his decision not to testify has been made freely and involuntarily, and the court will instruct the jury regarding his decision not to testify
he done.
at the applicable stage of the proceedings. So, Mr. Quiles, it sounds like your defense attorneys are calling a few witnesses to testify on your behalf. I have a general knowledge as to what they're going to say. Obviously, you have more in-depth knowledge than I do at this ballgame because they've talked to you about all this. Have they located the witnesses that you want them to locate to call on your behalf at trial?
Yes,
And you're in agreement with them calling these witnesses to testify on your behalf?
yes,
And I believe there's 3 of them?
yes,
Okay, and you're in agreement with that?
yes.
There's no additional witnesses that you want them to call that they are not calling, is that correct?
You couldn't find the other one, so
We talked the John Smith and the Larry.
correct.
Well, I think the John Smith issue got debunked by the states.
What the issue is, Judge, actually during the course of the trial, it popped up in the phone record. It's not John Smith. It's a different name. It's John Anthony. So it popped up during the course of the trial. The state did provide information. We did attempt to follow up. But given that the person's out of state, we are unable to complete our follow-up investigation and produce that person. But it was not a John Smith. It turned out to be a John Anthony.
Have you talked to him?
We have not been able to reach him.
I did call the phone number that was provided.
These people slow.
So he may call back today at some point, but at this point, he's in, I believe it was Georgia, if I'm not mistaken. Yes, okay. He's in Georgia, and so the likelihood of being able to provide him here, at this stage, it's,
Do you know what he allegedly would say? He was a coworker at the Ace Pick Park?
We have no idea. That's the whole.
the expectation, Judge, would be that our understanding is that he is on some of the video that the jury observed of him at work. He was with another gentleman during a portion of that video. That gentleman worked with him throughout that day. And so I don't know exactly what he would say specifically, but we would expect that he would provide information as to observations he made of Mr. Quiles that particular day.
Well, there are quite a few people who worked at Ace on that day. We can all agree to that, right?
Of course, but this,
And none of them are being called to testify.
no, and this particular person is someone who worked with him on a regular basis. And so this is someone who might remember that particular time. I think we.
I don't
did
know
reach
why the
out
judge
trying to figure
asking
out
that
whether he
question.
May have worked with him, but we just could not find anybody who remembered that particular time. So
Because to them, it was just a regular day. There was no reason for them to specifically remember this day.
correct. And so they couldn't provide us with any information that would be something to put in front of a jury. Other than
Okay.
speculation of, oh yeah, I don't
Ooh,
remember anything abnormal, which I believe both of the Lindros testified to that. So I don't think there's anybody else out there that we could have. This person in particular that Mr. Quiles requested us to try to find, he believed would have a little bit more direct information as to where his movements and activities.
Well,
throughout the day.
he's not there.
Not knowing that name, of course, Anthony versus Smith, that obviously impeded us from being able to fully investigate that prior. And we literally received that towards the end of the day or middle of the day yesterday. So it's not like we had a great amount of time to do any additional legwork.
And then Larry was the other person that had no last name.
We did figure out Larry. Larry was the supervisor that's been discussed as having been on leave during that time period. He was not present during any of those days, so we did not pursue calling Larry, although we did have the information for him, and we did discuss that with Mr. Quiles.
Okay. So the only issue being John Anthony.
Correct.
Okay.
Come on, Judge. You told them to hurry up.
Made every effort to make sure no stone is left unturned.
Understood. So Mr. Quiles, going back to you, sir. you're in agreement with these 3 witnesses being called on your behalf, correct?
Correct. Yes, sir.
Okay. And so when I asked you about any additional witnesses, it was the previous issue that we discussed regarding John and Larry.
Yes.
Other than that, is there any other issue or witnesses you want your attorneys to call to testify at your trial?
No, sir.
Have they done everything that you asked them to do in this case?
Yes.
Obviously, throughout the course of the trial, I've noticed that you've taken extensive notes on a legal pad. I've seen you talk to Ms. Michelle and Mr. Davis quite a bit. You've been engaged throughout the entire trial. You've taken quite a bit of notes from what I could talk. I don't know what you're writing, but you're writing something. And you've been conversing, ripping papers up, giving to your attorneys to ask questions, I'm assuming, of certain witnesses. Have they been engaging with you throughout this entire trial?
Absolutely.
They've been taking your advice of issues
Oh, come on,
that you want them
Judge.
to address.
Yes.
And you
Like
believe
you-
that they've done a good job for you?
An excellent job.
Good to hear. So I'm assuming based off that you're satisfied with their services here at this trial.
He's
Yes,
a
I am.
strange looking man.
Is there anything else you want to bring to my attention?
No, sir.
Has anyone told you how to answer my questions here today?
No.
Anything else the defense wants me to inquire about?
No, Your Honor.
Anything the state wants me to inquire about?
No, Your Honor, thank you.
Okay, so at this point, we'll go straight through the morning. We'll take an earlier lunch. We'll see where we're at.
He's still talking about
Rebuttal
eating.
case or not, but if not, we'll start
Oh,
closings this
I'm
afternoon
sorry.
after the lunch hour.
Judge, could I inquire, when you had the clerk come get me, I was in speaking with one of the witnesses in the conference room. As the jury's coming back in, can I go finish up with him to make sure he's ready and on deck to be called when Ms. Michelle's ready?
He's not the first witness,
No, he's going to be the second witness
so you want to talk to him in the interview room while Ms. Michelle is inquiring?
of the first witness that she's going to call, yes. Just so that we have
Okay,
ready to move him straight to the chute and ready to call.
the staff can accommodate you. I'm sure it can happen.
Thank you, Your Honor.
Okay, any reason why we can't bring the jury in?
No, Your Honor.
Defense?
No, Your Honor.
Okay, let's bring the jury back in, please.
Oh, dear, we ain't for no judge. Oh, there go Auntie. We see you, Auntie. Auntie got in the camera, honey.
Your Honor, the jury's re-entering the court.
He Google eyed.
Members of the jury, welcome back. Everyone may have a seat. Sorry for the slight delay this morning. I had to do some work with the attorneys outside your presence. Because of that, what I'm probably going to do is take an earlier lunch break for you guys. If that presents an issue for any of you guys, let me know. I'm not going to go to 12:30 straight. I promise you guys. If I take an earlier lunch, if that presents a problem, slip a note to the bailiff. I'll certainly accommodate you guys. But with that said, we're going to begin. The state rested their case in chief yesterday. You guys all have your correct notes? Okay, people are shaking. Okay, good. So the state rested their case yesterday. I'm going to move forward to the defense side. Mr. Davis, Ms. Michelle, you can call your first witness.
Defense would call Carol Flip.
Well, at least he got a witness. Henry Dinkins didn't even have no witnesses.
You solemnly swear affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God.
Ms. Clip, good morning to you, man. Come over here to your right. Just watch your step as you come forward. Need a glass of water, let us know. Mr. Gray and the staff will certainly accommodate you.
I'm nervous, but I think I'll be fine, thank you.
Yes, ma'am, but no reason to be nervous, but I understand why. You can manipulate that microphone to help you project your voice.
Must be his
If
mom.
I just asked if there's an objection made by one of the attorneys during your testimony, just pause, let me rule on the objection, and we'll go from there, okay?
Yes, sir.
All right, ma'am. With that said, state you may inquire, you're ready.
Yes, Judge, thank you. Good morning, ma'am.
Oh, there you are.
Yes, I'm ready. Good morning.
Good morning.
Could you please begin by introducing yourself to the jury, please?
My name is Carol Ann Clip, and I live here in Jacksonville. And I work for the health department half my life.
Thank you so much for giving us that. Are you related to anyone in this case, Ms. Clip?
No, ma'am, I'm not.
Do you know anyone by the name of Johnatha Quiles?
No, ma'am, only through this instance now.
And did you hear that through the news?
Excuse me?
And did you hear his name through the news?
Yes.
Okay. Outside of hearing his name on the news, had you ever met him or spoken to him or know anything of him?
No, ma'am.
Do you know, maybe from the news as well, outside of what you may have heard on the news, did you know a young lady by the name of Ayanna Sawyer, IS for the record?
No, ma'am.
Did you know anyone that was related to her at all?
No, ma'am.
Do you recall a time in December of 2018 where you witnessed something noteworthy?
Yes, ma'am.
Can you tell us what you witnessed?
I was coming home from my mother's house in Tampa at Christmas time, and it was actually the late afternoon or evening of Christmas. And I came down off the 95 ramp to come down on Phillips Highway. Well, I had to stop at that light there. It just wasn't green and you could just go. So I was stopped behind several cars, and the light turned green. And as the light turned green, I went and merged onto Phillips Highway. And as I did, I noticed this young girl walking in front of the two hotels there. There's two hotels right side by side. And I noticed her and I thought to myself, it's going to be dark soon. You know, no young person should be walking down headed south on Phillips Highway when it's going to be dark shortly. And I was concerned. And then I got home and I didn't think anything more of it.
All right. And you said that you were concerned. Is that something that you thought about later and wondered about what was going on with her?
Well, later on, I think it was several days, I saw on the news, I was actually sitting in front of the TV, and I saw the news about the missing girl. And through their description and the picture I saw of her, that was her. In my heart and mind, that was her. And so I had to call the police and say that I had seen her.
And did you do so?
I did so.
Did you do that right then and there?
I did that the very day I saw that on the news, yes.
When you called her, did you tell police what you've relayed to the jury just now?
Absolutely. And I probably even went further because it was more fresh in my mind.
And I was going to ask you some of those details. I know you told us where you saw her and you saw her walking. Do you remember what she was wearing?
I remember her hair. I remember a backpack. I remember, that's about all I remember. But I know that whatever it was, I told the police whether it was more or less was what I saw, which was more fresh in my mind 4 years ago.
Of course. And when you made that phone call, why did you call right then and there? Tell us your thought process.
Well, because
Got into what she was saying. Sorry about that.
When you saw that news
The TV man.
picture and the description that you called then, how certain are you that the young
That's not me.
was in fact that same young lady that you saw in the news that was missing, IS?
well, if I was not certain in my heart,
Wrong with you?
there would be no reason to.
Let me ask you a couple last questions. Did you want to come here today to testify?
It's kind of scary.
It's scary.
I was going to ask you that. Is that why you are testifying?
That's why I'm here.
And what you've told us is what you saw. No, as best your memory can recall, no additions, no subtractions.
No, that is true. This is what happened.
Thank you.
You're welcome.
Nothing further.
What is wrong with the cameraman today?
Yes, ma'am.
She needs to drink some water.
Besides the nervous part, huh?
I've never done this.
So, ma'am, I'm going to obviously talk to you about back in December 2018 and January 2019. This individual that you observed, it was on December 26, 2018, between 5 and 6 p.m. Is that correct?
It was the 25th. It was Christmas.
Do you recall telling the police that it was December the 26th, 2018?
No.
Okay. And do you recall?
Oh, you know what? It may have been because I spent Christmas at my mother's. Pardon me.
That's okay. Did that help refresh your recollection?
Yes, thank you.
No problem, ma'am. And you had told the police that it was between 5 and 6 p.m. Is that fair to say?
If that's what I told them, then that was the truth.
And it was getting dark, wasn't it, at this time?
It was going to be soon, and that's why I was concerned for that young person.
And you recall the fact that this individual had a backpack.
I do.
And I think the other thing that you remember is that this individual had hair extensions.
I do.
Good morning, Shirley.
And you stated that then on January 1st, that would have been 5 days later, correct? That you saw a picture on the news?
Possibly, yes.
Okay.
I knew it was several days. I don't know the date.
Do you recall what picture you saw on the news?
I do not.
And had you ever seen the individual by the name of Ayanna Sawyer before?
I don't believe so.
And
I was what, ma'am?
it's fair to say that you were driving at this time, correct?
I was driving. I was stopped. The light turned green, and I proceeded around to Phillips Highway.
Yes, ma'am. Is it fair to say that the total time that you saw this individual while you were moving was 5 seconds, correct?
About 5 to 7 seconds, yes.
No further questions, Your Honor.
Ma'am, good to see you.
What the cameraman doing?
Ms. Michelle, you can call your next witness. Yeah.
Your Honor, if we could next call Ulysses Dixon.
I'm aware. Yeah, I think Officer Hill tried to ask him outside.
Another inmate. Look at the cameraman all over the place. Look at him just moving. Camera.
I know. I just didn't know you.
Got an inmate, y'all. Got an inmate. Uh-oh. For the witness.
Mr. Dixon, good to see you, sir. Just walk up here in front of the clerk.
Uh-oh. Oh, Jonathan got a friend. Look at him. Oh, head joker.
Mr. Dixon, good morning to you, sir.
Good morning, sir.
You need a glass of water, let us know. We'll do our best to accommodate you. If an objection made, I just ask that you pause, let me roll the objection. We'll go from there.
Yes, sir.
All right, with that said, Mr. Davis, you may inquire. You're ready.
Thank you, Your Honor. Good morning, Mr. Dixon. Would you please state your name and introduce yourself to the jury, please?
My name is Ulysses Darrell Dixon II.
Okay. And where are you currently housed?
I at the PDF detention facility at the county jail.
Okay. So you're at the Duval County Jail, right?
Yes, sir.
How long have you been at the Duval County Jail?
I've been at the Duval County Jail for about 6 years.
Okay.
Wow.
Now, just to be clear, 5 prior felonies, right? In your history?
Yeah, I don't know how many, but yes, I have felony priors.
Okay. And you have pending charges as well, correct?
Yes, sir.
How many pending charges do you have?
I think the state amended it when I was about to go to trial. I think it's like 13, 12, 13.
Ooh-wee.
Now, are any of those crimes of dishonesty?
No.
Okay. You don't have prior crimes of dishonesty?
Oh, that's not what no, sir.
All right. Now, at the jail, are you involved in a Bible study group over there?
Yes, sir.
And how long have you been running a Bible study group at the jail?
Since 2018.
Okay. And do you run the Bible study group?
Yes, sir.
Okay. It's something you set up on your own, right?
Yes, sir.
It is not affiliated with anything through the jail or some other religious or ministry group or anything like that, correct?
Correct.
All right. Now, do you give incentives to people that come to your Bible study group?
Definitely, like food and extras. Yes, sir.
Okay. And do you follow up with people that come to your Bible study group on a regular basis?
Definitely.
Okay. And just to be clear, this is done in the dorms there at the jail, correct?
Yes, sir.
All right. Do you do an outreach program to recruit new members and get new people that are coming in to attend your Bible study group?
Yes.
Okay. For lack of better words, are you basically like the minister or conduct this ministry yourself?
Yes, sir.
You bring in a minister to participate in this?
Do I try to encourage other people to preach? I do.
Okay. All right. Do you have an occasion to know the name Damian Hatch?
Damian Hatch. Yes, I do.
What name does he go by at the jail?
Dino.
Dino. Okay. And do you know Jonathan Quiles?
Yes, I do.
And how long have you known Jonathan Quiles?
I know John probably since either 19 or 20. It's been a long time. It's been a while.
When you say 19 or 20, you mean 2000?
2019, 2020.
Just so that
record's clear, let me finish my question and I'll let you finish your answer so that this young lady can take everything down, okay?
Yes, sir.
All right, thank you.
Why he looking
All
like
right,
that?
now, I want to go specifically to around February of 2022. Was Dino or Damian Hatch attending your Bible study group regularly?
Around 21, 22, yes. Dino was a regular.
Okay. And do you recall, or do you know, has Jonathan Quiles ever attended your ministry or religious groups?
John started right about the beginning of this year, maybe January, December, somewhere around the beginning of this year and the last year. But
So from 2018 until to the end of 2022, he did not attend your religious or ministry group.
no, he didn't. Though I tried to, convince him to start attending services and seek Christ.
How are you certain he did not attend?
Because I lead the Bible studies. I do Bible study after lunch. It's more in depth, get into, hermeneutical interpretations of the books. And then at 6 o'clock services, that's the main service where it's like preaching, hallelujah, thank you, Jesus, encouraging the guys, exhorting the flock to just continue in the doctrines of our Lord and Savior Jesus Christ. And he wouldn't attend. But he went by the name Brother John. So I was like, bro, you're a brother. I should try adamantly because he does a lot of good stuff in the jail, clipping toes for the old people. When the guys they have bowel movements on themselves, he watch them. He do a lot of good work, but he don't come to church. So that stuck out to me.
All right. And have you ever seen Dino and Mr. Quiles hanging out at Bible studies together?
No, because John don't come.
Okay. Well, he didn't come at the same time that Dino.
Yeah, not at that time. Dino was in Bible study. John wasn't.
So if somebody were to say that Jonathan Quiles attended your Bible study and was there with Dino, would they be telling the truth?
That Dino attended it with John, that's a lie.
Okay. Did you ever see them hanging out together after the Bible studies?
No.
Okay.
He said they used to.
All right. And how are you certain of that, of their attendance?
Well, I have records. I keep up with the flock. The Bible says be diligent to know the state of that flock. And so I keep meticulous records. I have the names of the regular main attendants. And if guys just pop up and make a guest appearance, so to speak, I write the names on the bottom in that section so I can follow up and say, hey, man, I seen you at church today. I just like the service, woo-doo, and just try to bring them in, usher them to Christ.
Before you came over here to testify today, did you review your records to ensure that they were accurate, that Jonathan Quiles never attended your services before this year?
Yeah, I turned them in to the people that came and asked me about them. They asked me, you guys asked me, and I said, I got records to prove if you think.
Okay. All right. You also showed those to detectives when they came and talked to you?
No, the detective, I didn't show them to the detectives. I didn't know why they was calling me out.
Okay. All right. May I have just a second with Council here?
He said the man was there now. He said, but not then. What they trying
Morning,
to say?
Mr. Dixon.
Good morning.
Get him state.
Now, sir, you have pending charges that you're currently facing right now. Is that correct?
Yes, sir.
And there's 13 of those, right?
Yes, sir.
You brought them up. What are they?
What are my charges right now?
Yes, sir.
I have human trafficking, deriving financial support from the proceeds of prostitution.
What?
There's kidnapping. There's a
What?
aggravated battery,
What?
possession of firearm, sexual battery.
Woo.
All right. You left a few out, didn't you, sir?
I think I was correct with all of them.
Okay. You said human trafficking. Is that correct?
Yes, sir.
Isn't it true, sir? You have 2 counts of human trafficking charged against you.
Yes, sir.
And then you said sexual battery. Is that correct?
Yes, sir.
Isn't it true? You have 6 counts of sexual battery charged against you.
Yes, sir.
And then you mentioned kidnapping. Isn't it true, sir? You have 2 counts of kidnapping charged against you.
Yes, sir.
And you have 1 count of aggravated battery. Is that correct?
Yes, sir.
And then you have 1 count of deriving support from the proceeds of prostitution. Is that correct?
That's what I said.
And then you said a possession of a firearm. Did you mean possession of a firearm by a convicted felon? That was charged with?
Yeah, that's more formal. Yes, sir.
Okay, thank you. Now, you are a convicted felon, right?
Yes, sir.
How many felonies do you think you have?
Pimp. P-I-P.
Well,
P-I-P.
2,
Okay. Counsel asked if you had 5.
4. I don't know. Probably 3, 4, 5, maybe.
You said too.
You
I mean,
keep meticulous, detailed records about who attends your Bible study, but you don't know how many felony convictions you have, sir?
I mean, if you gave me my record, I could show you that, like I could show you the records for my Bible study.
I'm asking you about what you think. How many felonies do you have?
2, 1, 4. I thought I had 4.
All right. Now, these charges have been pending against you since 2017, right?
Correct.
And they were filed by the state attorney's office that I'm a member of, correct?
Correct.
And you agree, sir, that you're fighting those charges.
Yes, sir.
They're pending right now.
Yes, sir.
Look how he looking.
Now, this group that you lead over at the jail, excuse me, this takes place in the pod, in the dorm. Is that correct?
Yes, sir.
Like, if I'm laying in my bunk on the 1st or 2nd floor, the group can be heard right down there in the pod, correct?
Yes, sir.
In fact, you can see from each respective bunk, you can see in the dorm when the group is meeting, right?
Yes, sir.
In fact, everybody can see it.
Yes, sir.
In fact, when you meet as a group, do you agree, sir, that you meet at one section of the open dorm that's open to all?
That's changed.
I'm talking about back in the time period you're testifying about. Not now, not today, but back when we were talking about 2022, 2021, 2020, 2019, right?
When we made that conversion from the secluded area to the open area, that was around about 22.
Okay. And the defendant, you've seen him in your dorm since 2019, correct?
I don't believe I was in the dorm with him at 19.
All right. You said to this jury just a few minutes ago, sir, under oath, that you've known him since 2019.
From 1920. We weren't in the dorm together when I first met him.
All right. How'd you meet him?
He works in the jail. He was a trustee, what they call it, pass out the trays, help people, stuff like that.
All right. When did you become a fellow inmate in the same dorm or pod with him?
Probably 20, 19 or 20. I'm not
Okay.
sure about that.
All right. And in 2019, 2020, he was new to you when you first met him, obviously, right?
Correct.
And when you are doing your Bible study, can it be heard over the whole entire pod, the whole dorm?
Yes, it can.
All right. And how many people are in this group?
It varies. It fluctuates between 10 and 30. It fluctuates between that.
All right. And when the group breaks, I take it you in with a prayer?
Prayer.
And when the group breaks, everyone just disperses, correct?
Shake hands, dap up, hug, and then they go their separate ways, put up their Bibles and go back to what they're doing, get on the tablets and the phones.
Yes, sir. And when these either 10, 15, up to 30 people break, are you watching every one of them?
Not every one of them. I hug and dap up every one of them. I don't watch what they do after they leave.
So when you say leave
morning.
the Bible study group, you agree with me, you cannot watch all whatever number are appearing on that particular day. You agree with that, right?
That I can't watch all of them after the service is over?
Yes, sir.
No, I can't watch all of them at the same
And when
time.
the service is over, if we're meeting over here in a group and you walk 10 feet away, you're no longer with the group, right?
Correct.
And as you get further away from where you're meeting, you can't hear what they're saying, right?
Correct.
Pretty loud in there, right?
Correct.
I mean, this jury's heard a wire. You hear banging on doors, correct?
Correct.
You hear that quite often in there, correct?
Correct.
You have no idea what any member of your group is talking about or who they're talking with once they leave your group. All 30 of them, can you, sir?
Yeah, I don't see what they're doing after they leave the service.
They got a PIMP for a preacher.
One moment, Your Honor.
Oh, they got a PIMP for a preacher, boy. God.
Sir, thank you.
Oh, y'all some.
Follow up on what Mr. Skinner had just asked you a minute ago, sir. Back a year plus ago, the way your Bible group met, you said it was in kind of a secluded off to the side area?
Yes.
Was that accurate?
That's accurate.
Okay. So although people inside the dorm can hear it, that you're doing this Bible study, you can, when they were attending, it was like in a separate off to the side room or area, correct?
That's where we do church at.
Okay. Now, as such, it's kind of off, as you stated, off to the side. You can tell who's attending and participating in your church services, correct?
Correct.
And as part of that, if somebody states that they saw Dino and Jonathan Quiles together at the church service over there off to the side, they would not be telling the truth. Would that be accurate?
They would be lying.
Okay.
John didn't go to Bible studies. I mean, after church over with, I stay at church, walk everybody to the doors, leave them this way or that way. How they would do at a real church, how you walk your members out the door.
That boy did go to Bible
I
study
would
with
shake
that
their
boy.
hands and tell them God bless you until the last member gone, because people want to talk to you after church. And so I stay. So if anybody else stay, I would see that. But if they go somewhere else, if they go to a room, if they go in the shower together, I can't see that.
Okay. Now, one last question. Anybody promised you to be here today? Promised you anything to be here?
No, actually, I feel threatened that if I, come forward with information, that they may respond against me. The state attorney's office may try to go hard on me for my charges. But, they trying to kill this guy, and the dude was lying on him. So I told him, I would agree to tell him that, man, that's a lie. The dude lying on him.
Nothing further, Your Honor.
All right, Mr. Dixon, have a nice day. Spence, you can call your next witness.
Bye, Phil.
Call Kamar Humphrey.
Ooh. Bye. He was in that Bible study with that boy. Johnatha think he's slick. Well, good morning, Miss Tina. Oh, look at y'all. Y'all got on the bus together. What's
Mr. Humphrey warned you, sir. You just come on forward, and the clerk right here will swear you in.
Okay, baby. You
Mr. Humphrey, come over here to your right. Just watch your step as you come forward. If you need a glass of water, let us know. Mr. Gray, staff will accommodate you. Do you want one? Yes, sir. Okay, Mr. Gray will help you out with that. The microphone can be adjusted to help you project your voice. You seem like you have a soft voice, so just try to project your voice with that microphone so everyone can hear you. You can scoot forward however you deem necessary. If there's an objection made during the course of your testimony, I just ask that you pause, let me rule on the objection, and we'll go from there, okay?
Yes, sir.
All right. Ms. Michelle, you may quite ready.
Yes, do you want a moment to get the water? Okay, I'll let you have a moment to do that.
Well, look at Michelle being cute with the men's today.
You ready, sir? All right. If you could please, sir, start by introducing yourself to the jury, please.
Hi, my name's Kamar Humphrey.
All right. And Mr. Humphrey, how old are you?
I'm 25.
And where do you reside currently, just generally?
North Carolina.
And back in 2017, 2018, where did you live?
I live in Jacksonville,
And where specifically?
7843 Indian Avenue.
All right. Sir, if you could, do you recall a time period around February and March of 2018?
What was your question?
Do you recall a time period around February or March of 2018?
Which time period are you talking about?
Where did you reside around February or March of 2018?
Sure did.
It's on Indian Avenue.
And sir, did you have neighbors at that time that you knew to be Ayanna Sawyer?
Yes, ma'am.
And how did you meet IS?
Walking up, neighborly, just walking up the street, picking up my little cousin from school, and she'll be picking up her brother from school.
And did you all talk to each other and have conversations?
Slightly, yes.
At some point in time, did you all start communicating more?
Yes.
And how would you all communicate?
We communicated through social media.
Okay, and what social media apps did you use specifically?
Snapchat.
On Snapchat, do you recall what your Snapchat was at that time?
No, ma'am.
Do you recall what IS's Snapchat was at that time?
No, ma'am.
Do you recall IS having multiple Snapchats?
No, ma'am.
Do you recall having a conversation with her about those Snapchats or anything about Snapchat at all?
No, ma'am.
How did you all exchange information?
Like I said, I met her while walking, so we were just neighborly like that.
Did you all exchange phone numbers at one point?
No, ma'am. No phone numbers.
Did you all exchange social media handles? Is that how you got connected?
The Snapchat, yes, ma'am.
Was that the only social media accounts that you used to communicate with IS?
Yes, ma'am.
All right. In March of 2018, did police come to your home?
I believe so, yes, ma'am. In March, yes, ma'am.
And what happened when police came to your home?
I believe this is the time I did the mouth swab, I believe,
And what did they tell you why they were doing that mouth swab?
for a rape kit or something like that.
Were you in a sexual relationship with IS?
Can you describe a sexual relationship?
Whatever you believe a sexual relationship is, were you in any sort of sexual relationship with IS?
Yes,
What?
How many times had you and IS slept together?
once.
Have you ever stated anything differently than that?
At one point, what do you mean? Have I ever stated? What do you mean?
Have you ever said that you slept with her more than once?
No, ma'am.
Have you ever denied having slept with her at all?
Yes, I did. I did deny.
Why you lying?
When was the last time you denied sleeping with IS?
With the deposition that we had.
Do you recall when that deposition was?
No, ma'am, I don't actually remember the days that we talked on Zoom.
Was it just last month?
Yes, ma'am. It was recently, yes.
In fact, it was just like a few weeks ago, in fact.
Yes, ma'am.
And a few weeks ago, you said you never slept with IS.
Yes, ma'am, I did.
That was not the truth, correct?
That wasn't the truth. At the time, I felt like you were attacking me when you were asking me questions, and at that time, so yes, I did.
All right. Let me ask you about following that. You're saying you only ever slept together one time?
Repeat your question.
You just testified you believe you only slept together one time, correct?
Yes, ma'am.
Okay. Did you all have a continuous relationship thereafter?
No, ma'am.
Did you all continue to communicate on Snapchat?
No, ma'am.
How long, if you could estimate for me, how long you all were communicating on Snapchat? Are you having trouble hearing me?
A little. I'm just trying to make sure I hear your question as clear as possible.
That's right, baby.
And I'll elevate my voice that way I make sure you hear my question fully. Did you
You
hear
ain't
my
got
last
to
question without any issue? You're kind of leaning your ear towards the,
Could you repeat it one more time?
of course. How long in total do you believe you communicated with IS on Snapchat?
Probably like a month or two. It wasn't that long.
After police came to your home and asked you about this sexual encounter that you had with IS, did you continue to see her?
No, ma'am.
Did you continue to live on India Avenue?
Yes, ma'am.
From the time that this occurred up until when did you continue to live on India Avenue?
Repeat your question again.
How long did you continue to live on India Avenue?
For a couple years until I think the year of 2020 when COVID hit. That's when my aunt and my uncle moved. I was living with my aunt and my uncle. We moved to St. Augustine.
So during the time period of December 2018 and the months leading before that and after that, you were living on India Avenue across the street from where IS was residing.
Yes, ma'am.
At no point after you were accused of having sexual encounter with IS did you move away until 2020.
Could you repeat that? You said a lot when you were.
I know. Let me slow it down. During the time period before December 2018 and immediately thereafter, you continued to live across the street from IS.
Yes, ma'am.
Did you see her?
No, ma'am.
You would not see her at the bus stop picking up her siblings.
No, ma'am.
Did you stop picking up your siblings?
Yes, ma'am.
Did you go outside of the house from time to time?
Yes, ma'am.
Did you see other family members at any point outside of your home of IS?
I wasn't really paying attention to the family. I was just focused on work.
Do you recall in December of 2018 being visited by police at your place of employment?
Yes, ma'am.
Where were you working at that time?
Popeyes off of Arlington.
And I know you probably don't remember her name, but it was a female detective that came to see you.
Yes, ma'am, it was.
Okay. And what did she ask you at that time, if you can remember?
And she just asked me, did I see her, and if I had any thing to bring to her or any information just to contact her.
Okay. At that time, did she also ask you where you were on December 19th and 20th?
Did she ask me? Repeat that one more time. I'm sorry.
Did she ask you at that time where you were on December 19th?
I don't recall if she asked me. I don't recall, Sheriff. I know she just, like I said, I remember her asking me about, if I've seen her and if I have any information or anything about that, just to respond back to her.
Okay. And do you recall, I know you don't recall her asking you that question, but do you recall volunteering the information that you believe you were out of town from December 19th until December 29th of 2018?
I was out of town between the times of December 18th. I left December 18th out of town.
And do you recall telling the officers that it was actually December 19th through the 29th?
No, I don't recall telling the officer December 19th. I don't recall telling her December 19th.
Okay. Have you ever stated that you were out of town on different days than those dates that you just provided of December 18th?
Yes.
Okay. In fact, just a few weeks ago, didn't you tell me that you were in town on the 19th and the 20th?
No, I did not tell you that.
Do you recall ever saying that you were only out of town from December 21st through December 23rd?
I recall telling you that because like I said, in the deposition that we had, I felt like you were attacking me and I gave you the wrong dates.
What?
Do you recall telling me that you took a plane on December 21st to go visit your dad?
Yes, I remember telling you that.
Do you recall checking your calendar to figure out what dates you were gone around that time period?
Yes, I remember. And I didn't take a plane either. I took a bus.
Do you
Y'all don't get-
recall having any information at your disposal at that time to be able to verify those dates?
At that time, no, ma'am.
She
So
sure
did you
is.
in fact look at your calendar at that time just a few weeks ago?
Repeat your question.
Did you in fact look at your calendar a few weeks ago to figure out that you were gone the 21st to the 23rd?
I looked and found that I was gone between the dates of the December 18th through the 28th, I believe it was, or 29th, to go see my father in Harrisburg, Pennsylvania.
And let me ask you another question. Do you remember your response to when I asked you about what airline you used?
Again, no, ma'am, because again, like I said, when we had the deposition, I felt like you were attacking me when you were asking me questions. So I was not truthful with you. And I came back and I apologized because, I should have been truthful. So, no, ma'am.
And I know the incident's from quite some time ago. Is there a reason why you would feel attacked when asked when you were out of town or in town?
Because I was trying to get this situation behind me. I've been focused on myself and getting my life correct, and making a better life for me.
So someone asking you where you were, was that you felt like that was an attack?
No, not that specifically, just the whole conversation of what we were having, and the way that you were, coming at me and talking to me. Yes, I did feel like you were attacking me.
Was I talking similarly to how I'm talking right now, asking you these questions?
No, ma'am. You were talking differently.
Nothing on them now.
Right. Let me ask you about your whereabouts during the 21st to the 23rd. You stated that you were where?
I was in Harrisburg, PA.
Right.
Pennsylvania.
And you're certain that you were not in Jacksonville during those dates?
I'm positive. Yes, ma'am.
Do you recall seeing IS's sister on Christmas of that year?
No, ma'am.
If SS said that she saw you on Christmas of that year, would that be incorrect?
Yes, that would be incorrect. She would be lying.
Chill.
One moment.
And that's her witness, y'all. That's Michelle witness. He don't remember nothing. The state about to burn you
Mr.
up, boy.
Humphrey, outside of the female detective that came to your job, have you ever been contacted by police at all as it relates to your involvement in this case?
No, ma'am.
Has anyone ever followed up with you as it relates to your whereabouts around that time?
No, ma'am.
Did you ever provide confirmation of your whereabouts to police for your time period of the 19th or 18th, I'm sorry, 18th through the 28th that you gave us today?
Repeat your question.
Did you ever provide confirmation of your whereabouts to police from the dates that you provided, December 18th through the 28th?
At the time that they had asked me, or prior to recent?
Yes, did you ever provide it to police?
When exactly are you asking that I provide this information?
Did you ever provide that information to police is the question.
No, ma'am.
Okay. Did they ever follow up with you to try and obtain that information from you?
No, ma'am.
Recently, you provided this information to the state attorney's office, correct?
Yes, ma'am.
And that is not a bus ticket, is it?
It is a bus ticket.
Does it verify that you actually got on the bus?
Does it verify I got on the bus? I did get on the bus. I did.
The question is, does that ticket that you provided to the state attorney's office verify that you got on the bus?
Yes.
Does it state on there that you actually used that bus ticket?
No. I'm trying to understand what you're saying.
Just asking, other than you stating that you left, is there any independent verification that you actually got on a bus and went to Pennsylvania?
I went to Pennsylvania.
And let me ask it again. Is there any verification of that you have?
That I have.
Objection, Your Honor. Asked and answered.
Your Honor, he did not answer that question.
I think he's answered it, but I'll overrule it. He can answer this one last time and we'll put the issue to bed. So you can,
I'm asking about verification. I'm sorry, Judge. I thought you were done.
no, it's fine. I was going to say if you needed to repeat your question or if you remembered the question.
Of course.
I don't remember at this point. So why don't you go ahead and re-ask the question and we'll see what the answer is and we'll go from there.
Yes, I'm not asking whether you say you're in there. I said if there is any independent verification of that you have.
I mean, whenever I scan my phone for the ticket to get on the bus, yes,
Right. And you've provided that information to the state attorney.
already, yes,
And that was just a couple of weeks ago.
yes,
When this was asked of you about last month, you said differently though, correct?
When I talked to you, yes, when I talked to you, I did say differently.
He don't like her. Oh, Michelle, man. Big man. Sure is.
Just a moment.
He's sick of Michelle. He got on her yesterday. That's why she talking like that. See, she be snapping on people. That's not nice. And he handled her very well. Oh, Lester, I
Good
thought
morning,
he was.
Mr. Humphrey.
Here we
Want a
go.
glass of water?
Good morning.
Okay. Go ahead. I just want to check on the juror. You're fine. Go ahead, State.
Yes, sir. Thank you. Now, Mr. Humphrey, counsel didn't bring it up, but did you talk to the news about this case?
Yes, sir.
In fact, after IS went missing, you went on camera, did you not, sir?
Yes, sir.
And you told the news that you were hoping for anyone out there to provide information, correct, sir?
Yes, sir.
You're being a good neighbor, weren't you, sir?
Yes, sir.
Trying to help find IS, correct, sir?
Yes, sir.
You knew her from before, your encounter before, correct?
Yes, sir.
Cooperating, putting your face on camera. You agree with that, sir?
Yes, sir.
In fact, when you spoke to the news, you pleaded for anyone to come forward for information, correct?
Yes, sir.
He defended.
And you did that obviously after she disappeared. You agree with that?
Yes, sir.
And sometime later after she disappeared, I think the jury's already heard it's been some days before there was heavy media coverage. You willingly agreed to do that, right, sir?
Yes, sir.
Right. It wasn't until the deposition with Miss Michelle is when you started getting, you were misrepresenting things, correct, sir?
Yes, sir.
You didn't hit it off with her, did you?
No, sir.
All right.
That's DL
Now-
right there.
Mr. Humphrey, did you have anything whatsoever to do about the disappearance of IS at all?
No, sir.
Now, these dates that we were talking about, you in fact were gone from December 18 of 2018 through December 28th of 2018, correct?
Yes, sir.
In fact, after that deposition, you went and pulled off your phone the exact dates and times of when you left town and when you returned, correct, sir?
Yes, sir.
You provided it to our office, did you not, sir?
Yes, sir.
You apologized for misrepresenting yourself in that deposition, did you not, sir?
Yes, sir.
Sir, were you in Harrisburg, Pennsylvania from December 18th to December 28th of 2018?
Yes, sir.
Do you even recall sitting here today what times you got on and off the bus?
No, sir, I don't.
Requested, I'm sorry, Your Honor.
Michelle don't know how to. She
Yeah,
snapping in.
I'm sorry. I'm sorry.
You're fine. Just so the record for the juror asked me what you said as you went away from the microphone, Mr. Skinner. I told him you asked me permission to approach the witness.
Sir, is this the information that you provided the state attorney's office?
Yes, sir.
Did you pull that information off of your phone?
Yes, sir.
Is that from your records?
Yes, sir.
Will you tell us exactly what time you left Jacksonville, Florida on a Greyhound bus on December 18 of 2018?
It says leaving. I left from Jacksonville, Florida on December 18th, 5:30 p.m.
And what time did you arrive to Harrisburg, Pennsylvania?
Hold on. One o'clock p.m.
Was that the next day on December 19th of 2018?
Yes, sir.
And what was the date of your return trip from Harris, Pennsylvania back to Jackson?
December 27th to December 28th.
You departed Harrisburg, Pennsylvania on December 27, 2018 at what time, sir?
4:20 p.m.
And at what time did you arrive back in Jacksonville on December 28 of 2018?
1:00 p.m.
Thank you, sir.
That's DL, y'all. Remember, he liked it, the prosecutor too. He didn't like the defense.
Your Honor, request to admit the next numbered exhibit, I think is state 68. I have marked it as state exhibit triple P for identification purpose and requested.
Any objection?
Objection, Your Honor.
Without objection, mark as date 68.
Nothing further, Your Honor. Thank you.
That ain't the little boy Jonathan was jealous of, is it?
Mr. Humphrey, take a second. Go ahead. You ready?
Yes, ma'am.
All righty. Mr. Humphrey, you provided that information of that ticket to the state attorney's office a few weeks ago, correct?
Yes, ma'am.
So shortly after our deposition, right?
Yes, ma'am.
All right. During that deposition, do you recall consulting your own calendar and telling us the dates of December 21st through 23rd?
Again, you were very aggressive with me when we had the deposition. So I did and mess up with that deposition. Yes, I did.
Did you tell us that you were consulting your calendar at that time and verified that the dates you were out of town were December 21st through the 23rd?
I lied about the dates to you when we had our deposition. And I came forth and told the truth afterwards.
You also lied about whether or not you even had a sexual relationship with IS during that same deposition, correct?
Yes, because I felt like you were attacking me and trying to incriminate me at the time. Yes, ma'am.
You, in fact, had been charged and pled to this charge of that we're talking about from March of 2018, have you not?
I pled guilty to a battery charge, battery felony, and as a part of my plea was to take the stand.
Part of your plea was to come here and testify.
Yes, ma'am.
And is that part of the reason why it wasn't a lewd and lascivious battery charge as it was originally?
Repeat your question.
Is that part of the reason why it was dropped down from a lewd and lascivious battery charge to felony battery?
I'm not sure.
That negotiation that you made, that was between you and your attorneys, correct?
Correct.
And you're on probation right now
Yes, I am.
for that charge.
The Jergens Essential Oil Body Butter Collection. The feel-good feeling of Jergens.
Michelle, this boy your witness. This
With
is
false allegations.
Indeed, because of, like I said, previous, when we were having our deposition, you are very aggressive, and the words that you were using, I did not comprehend. So, yes, I felt like you were attacking me at the moment, and that's how I handled that situation.
The question of did you have a sexual relationship with IS you consider to be an attack?
Yes,
And that caused you to lie.
yes,
And the where you were on December 19th and 20th, that was an attack.
What do you mean that was a
Question.
Yes,
that
you were.
was
I
asked.
felt the way that you were asking me those questions and talking to me, I felt like you were attacking me as you
That
were
made you
asking
lie.
those
Sorry.
questions. I'm sorry, I didn't mean to cut you off.
No, I cut you off. Go ahead. Go ahead.
No, I'm not, like I said, you were attacking me at that time. Yes, ma'am. Go ahead.
And that made you lie.
Yes, ma'am. I was under pressure.
but you have to
Nothing
lie
else.
to.
Mr. Humphrey, good to see you, sir.
That's it.
That's it?
Thank you, young man. You can go home now, baby. Cause Jonathan trying to put it on you. Bye, Jonathan. Tell Jonathan
Mr. Michelle,
bye.
Mr. Davis, you can call your next witness.
Defense, Russ.
Good morning, everyone.
Members of the jury, it's 10:35. I need to talk with the attorneys outside your presence to determine our next steps. I have a couple options. Just to be transparent with you guys as to what I'm thinking next. I may merge the mid-morning break and our lunch break, make it just an extended time. It depends what's next. I don't know. You guys mind just stepping into the jury room for about 5 minutes? I'll have more information. That way I can let you guys know what's going on.
Oh Lord.
Please remember,
Here
don't
you
discuss
go.
the case among yourselves or each other.
Oh, this who keep putting me to sleep. Now he want to talk to them. Yeah, she was aggressive. She was aggressive to him on the stand. I wouldn't even talk. Oh Lord, he about to put me to sleep. I was doing good.
Jury's outside our presence. I still have counsel for the state defense. Mr. Quiles present. You guys may have a seat. State, do you have a rebuttal case? Okay, so you're ready for closings then?
Yes, sir.
Okay, what I'm thinking of doing is I got to give them a break, and there's reasons for that I don't want to put on the record, but I got to give them a break. It's nothing important, just for the jury's jury needs a break. What I'm thinking of doing is just giving them like an hour and a half break, come back maybe just after noon. I know that's an early lunch for a lot of people. I get that. I'm not sure coming back in 20 minutes or 30 minutes and going for an hour and a half is a good idea either, because then I still got to give them a lunch break. But if we start, let's say I start closing at 12:15.
You know, act
That's
like
just
he's
over an
ready
hour
to
and a half
go.
break for the jury and go straight through. I'll charge them tonight, and they can start deliberations. They say they said yes, or they can stay later tonight, and I'll tell them when I charge them that we are here as late as you want us to be here. Whatever you guys want to do, as soon as you guys want to break, we can come back tomorrow morning. That way they'll have all day tomorrow without me having to charge them or do closings tomorrow. But I think we should be able to fit all the closings in this afternoon.
Oh
Is
Lord,
everyone
I
okay with
did
that
work.
schedule?
State is.
And I would still give the jury breaks after state's first close, the defense closing, and then go to the state's rebuttal closing, and then I would charge them at that point straight, because the rebuttal closing the charge should not be that lengthy. And we can come back earlier to complete the charge conference. They come back at 11:45. We can complete that together. I'll give you guys. I'm happy to do it now or at the latter part of the lunch break.
He getting on my nerve. Let me be
Okay,
nice.
that's fine. If you guys are okay with it, I'll just let Mr. Gray know that the jury's free till 12:15. Okay, so the staff can let the jury know that they are on a break till 12:15, and then we'll come back out and recommence.
So they can ready to go on break, yeah.
Mr. Davis, at this point, are there any motions that you wish to make, given the close of your case?
Judge, we would renew our motion for judgment of acquittal and rely on our prior argument and case law cited.
Anything the state wants to add?
Just to reiterate our argument, as well as noting that the only attack of any of the confessions that we just heard was from Damian Hatch, not the wire, not Joseph Quiles. And with respect to the other two witnesses, Your Honor, our position is it doesn't change our argument to the court on the corpus delicti issue. We ask you to deny that.
The motions are denied. All right, let's go towards the jury instructions, if we don't mind.
So what he just want us to look at him? Let me be nice. Let me be nice. Take
I
a
would ask
deep
that you
one.
guys work off the copy that was emailed out this morning. Mr. Davis, Mr. Michelle, do you guys have copies of it?
Pulling it up now, Judge.
Okay.
For whatever reason, we keep getting bounced off the internet. That's why we keep losing everything.
He coming up with an excuse. The other man, the defense attorney.
Sir, Your Honor.
So they gone now on break. I know, honey. Let me take a deep breath and be
so
nice.
You have introduction to homicide. That's rather standard.
Be nice.
Murder in the first degree. Everything seems rather standard, and then they have the further findings with the firearm. Any objection from the defense in that regard? Introduction to homicide and the first degree murder charge.
What he doing? I ain't never seen nobody do this.
Objection.
Your Honor, in regards to the second paragraph under introduction to homicide, should we take out the comma after second degree before murder?
Yes. And after second degree murder, doesn't need to be a comma there. And after manslaughter. I'm sorry, ma'am. You're right. I'm making the corrections on my copy, so that's just grammatical issues. I'm taking out commas in one of the paragraphs. It's not a noteworthy issue.
I don't think he too much know what he doing.
How about the murder in the first degree as to count one? Any objection from the parties as to that instruction as provided?
Not from the defense, Your Honor.
8.
No, Your Honor.
All right, then we have.
That's what I'm saying. That's what I'm trying to find out. What he doing?
Anything from the defense? Any objection?
No objection, Your Honor.
They doing it now?
I'm fixing some grammatical issue and spacing issues. I will email this out again to everybody as well.
So Your Honor, probably seems.
Okay, then we go into the lesser included crimes. Is either party requesting any additional lessers other than second degree murder and manslaughter as to counts 1 or 2?
No, Your Honor.
Defense.
The world going on? I know he ain't doing what I think he
No,
doing.
Your Honor.
Mr. David, is that an issue that you guys have talked to Mr. Quiles about?
Right.
Can we just have a few minutes to talk to him to explain?
Of course, yes.
Is he doing his verdict? I ain't never seen nobody do this. I ain't never seen no judge do this. Is he going over a verdict? What is he doing? I need to rub his head. He don't know what's going on. If they going on lunch break, then I better close my eyes because I got to get out of here. He don't supposed to do it like this. He doing it in front of them. He gonna give the jury the charges. Oh, that they can brood on, but I ain't never seen them do this like this. He don't know what he doing. That's why he want to do it this way. He want to ask them for help, y'all, but he don't know how to ask for help like that. Man, y'all, me at work. Well, I ain't close my. I did real good. I ain't even snore or nothing. I did real good. Anita did not snore. Yay! I didn't go to sleep, but I was sleeping though. The jury is outside the. Yeah, I know they're not in now. He told them to go out and go to lunch or something. I don't know where he. All I know, I didn't go to sleep. That's all I got to say. They waiting on me to go to sleep. See, I ain't never seen nobody do this. See, he in the courtroom doing this. They used to go to their chamber, whatever it is. They just sitting in the courtroom. They ain't never seen no judge do this. Oh, that little boy, that dude was acting like DL. Remember DL liked the prosecutor, but he didn't like the defense attorney. That's how this guy right here was. He said, "You was being aggressive to me." That's the defense. So what? So ain't that what I said? I ain't never seen nobody do this. He can do this in his chamber, and I can take him. Charges for the jury. They don't supposed to do that in the courtroom. They need Miss Cunningham. Miss Cunningham would have straightened this whole courtroom up. But your honor, your honor.
You guys ready? Okay, so I think we left off with whether the defendant was in agreement with no additional lessers for counts 1 and 2, being that the only ones we're addressing are second-degree murder and manslaughter. And
I'm sorry. We are in agreement, Judge, and speaking with him, he agrees.
So he letting him know his charge. Let me tell you. Why are they? I like Miss
per
Cut.
the standard instructions, second degree and manslaughter are both category 1 offenses, since one party is requesting it and required to give it. And it sounds like the state's requesting that.
So, Your Honor.
Okay, so everything else, there's a category 2, which is a permissive one, and it has to be contained in the elements of the indictment or information that meet the facts of the case. Am I correct in saying that nobody's requesting any other additional category 2s for counts 1 and 2?
Correct, Your Honor. Can speak.
Okay. So, guys, take a look at the lesser included charge instruction for count 1. After I tell them that second degree murder and manslaughter are lesser included crimes for first degree murder, I'm thinking of telling the jury the following instruction, but because since we're combining instruction for second degree murder and manslaughter to make for simplicity reasons, and tell me what you guys think of this. The instructions for second degree murder and manslaughter as lesser included crimes for first degree murder are combined into one instruction for simplicity purposes. The only difference is the name of the victim and the elements of the crime. And obviously it will be sent out to you guys once you read it on paper. If you have any issues with it, we can talk about it as well. The only thing I'm trying to let the jury know is, and I'm sure you guys saw it on the paper, I tried to spell it out as easily as I could. I even spelled it out in the further finding for discharge and causing great bodily harm, that as to count 1, it's to IS, as to count 2, it's the unborn child. And I'll tell the jury that, and the verdict form obviously will spell that out as well. There should not be any confusion that
Well, y'all
two different
confused
victims,
me.
2 different elements, not combined into one element. If that makes sense. And I think the instructions clearly set that out. Okay. So for now, second degree murder, defense, any objection to how it's presented to the jury?
No, Your Honor.
State.
No, Your Honor.
You guys see how I spaced out how to count 1, it's IS, as to count 2, it's the unborn child, and that's as to count 1 and 3 of second degree murder. Then moving on to manslaughter, same thing for count 1 and for count 2 in that case, where the name of the victim is different, but everything else is the same. The objection to the second degree murder or manslaughter instruction.
No, Your Honor.
Okay, now we're going to the sexual battery charge in count 3. Any objection from the defense to that instruction as proposed?
Uh-oh, Lanita. Don't start, Lanita.
Your Honor.
All right, and state.
Yeah, Your Honor.
Okay, now we're on the lesser. State you're requesting lewd or lascivious battery.
Yes, Judge, and there actually is a potential issue with that as I was looking back. It might have
I
to
just need to put my eyelashes on.
since we're allowed to put on a more occasion, and a jury could convict for one occasion during that time frame, might also be a couple of different time frames. I believe that the evidence supports that the relationship occurred before and after. Therefore, lewd or lascivious battery
I
is only
will,
up
do.
to 15 years old, in 363 or 364, the day before their 16th birthday. So in order for them to be able to have if their verdict was a lesser included of lewd or lascivious battery, I think we would have to ask maybe for a further finding. I'll tell Mr. Skinner some more about it during the break, that they believe the date during that time frame would have been before her 16th birthday.
Wouldn't that be the finding by their verdict in that regard?
So that's why I know that there's been some issues in the past, so it's been a while since I was in sex crimes.
No, but I think their verdict would spell that out. If they're finding lewd and lascivious, they're finding that something occurred prior to her turning 16, not after she turned 16.
I understand, Judge, and I just wanted to bring it to the attention since
I don't think second degree.
It's been a while since I did sex crimes. Now, it didn't come to my mind until I'm actually looking at. I can look at that as well as a break.
Okay. Okay, but the sexual battery charge, everyone's agreeing with that instruction as proposed.
Yes, Your Honor.
Okay, then the lesser for lewd, that's a category 2. There are no category 1s for what's charged in the indictment. Defense, do you agree that as a category 2, even though it's permissive, given the elements of the crime and the facts of this case, the state is entitled to request that be on the verdict form in this case?
But can he get a bond?
Does the defense agree that even though it's a category 2 and it's permissive, that the facts of this case, given the facts of this case and what's charged in the indictment, the state's allowed to request this charge be read to the jury as a lesser to count 3?
Yes.
A lesser?
But there's a typo about halfway down where it says neither IS is lack of.
They trying to give him a lesser charge?
Oh, for chastity?
Yes, sir.
Okay, I fixed that.
What's going on? They're trying to get this boy a lesser charge.
Other than what the state mentioned regarding whether they're going to further research any objection to the lewd charge as proposed.
No, Your Honor.
Okay, so for data crime, the one thing I fixed here last night was that I think the state had count 3, the dates wrong per what was in the indictment. I fixed that. Other than that, data crime is rather routine, venue's routine. Plead not guilty, reasonable doubt and burden of proof is routine. I sent you additional instructions for the Williams rule instruction. Have you guys read that this morning? And let me know if you're in agreement with how I'm phrasing it. I'll fix the grammatical errors. And what I did was I took that directly from what I told the jury during the course of the trial. That's the exact language I used because I wrote it down in my notes.
State agrees.
What I tried to do was basically specifically tell them what this is regarding, so there was no confusion as to it. The general instruction is kind of vague because you may not have multiple Williams rule witnesses.
I don't
Defense, are you in agreement
understand
with
what's
that as
going
phrased?
on.
Yes, sir, Your Honor.
And then weighing the evidence, out of the 10 ones, which ones does the parties believe are not applicable to this case? I would say number 10 is not applicable for sure.
The state agrees.
Defense?
I don't understand. He can't tell them what to charge for anyway. Not the jury.
Doesn't apply.
Okay.
It's not a
I
bench
think
trial.
number 9 regarding felony or misdemeanor involving dishonesty is appropriate. Number 8 regarding inconsistent testimony is fine. Number 6 is preferred treatment. There's been allegations via cross or direct, so I'll leave it as is. Number 7, I don't think it hurts to include it in there, but I'll defer to you guys.
I don't know what's going on.
We would ask just for.
You can't tell the jury what to
Are you
say.
okay with it?
No objection.
So then, I'll allow the accomplice and informant instruction to be given. Are you guys in agreement with that?
Sir.
State?
Yes, sir.
And then child witness,
But the state ain't
I don't think
disagreeing.
that's really necessary given the age of the witnesses in this case.
Correct, they're all adults now.
Okay.
State agrees.
I'll take that out. I'll delete the instruction regarding if he testifies. Now I'll give the instruction regarding him not testifying.
Yes, sir.
The instruction regarding his statements. Is the defense want that included?
Yes, please.
State, are you in agreement with that?
That's fine, Judge. We agree.
I usually see it for like a police interview or something, which is not really what we have here, but
There was one, Detective Abbott talked to him at his house.
that's correct. Okay, that's fine. Rules for deliberation. The only thing I think we need to change is, and I highlighted in red, was in paragraph 5, where it says the judge's job to determine a proper sentence. That is technically true, but given what they've heard in this case during jury selection, that's not exactly what's going to happen potentially.
Man, that boy, but them folk,
I'm fine with deleting it.
he about to get
Or
guilty.
tell them at this point you are not to consider any issue regarding sentencing, or just deleting it. That way, it's not even that's why it's not even an issue in their mind. They're aware of everything given jury selection. That's not a secret to them at this
I was
point.
gonna say, we kind of harped on it for 3.5 days.
So I'm fine just deleting it. That way, it's not even bringing their attention to the issue.
State agrees.
Defense would agree.
Okay. Cautionary instruction, verdict form, single defendant, multiple counts. It's been the case with the jury. Okay, I'll email this out to you guys. Please let me know if you have any issues with it over the break.
I ain't never seen nobody do this.
And the verdict forms that the state proposed. The only addition I made is that in the caption, I put, instead of just putting verdict 1, verdict 2, I put verdict count 1, verdict count 2. Everything else seemed rather standard with the verdict forms. I fixed some formatting issues, and I'm happy to, spacing issues, I'm happy to send those out to the parties as well. But given the substance of the verdict forms defense, did you have any objection?
No, Your Honor.
State.
State, Your Honor.
So y'all, what so they not gonna start back
I'll
up
email
to.
this out as well for copies.
That's what I'm trying to find out. 12. So that means that, hold up. So
Other than that, anything else we need to handle? As state, if you can, I just need a copy. My copy will go back with the jury. Whatever else you guys want for your own self is fine. I just need one copy and one copy of the verdict forms. And I'll stable the verdict forms together myself. Don't worry about that. Anything else we need to handle?
No, Your Honor.
No, Your Honor.
Well, yes, sir. Very brief. The one email the court just sent, is that the one you want to copy? That was the final.
I sent 2 emails just now, one being the verdict form, one being the verdict forms, one being the jury instructions. The verdict forms seem fine to me. They're spaced out, which is fine. If you guys have any issues about it over the break, just let me know.
Yes, sir, Your Honor.
Yes, sir.
Anything else we need to handle before we take a break from the state's perspective,
No, Your Honor.
defense perspective?
No, Your Honor.
State, how long you're going to need in total for your closings? Now that you've thought about it overnight and here you are.
at 12:15. God, dog, I'm gonna miss a whole thing. I can look at it, but I just can't type or nothing. Yeah, they gone to lunch. Okay, so well, I guess we shoot that mean I can get me a little nap in before I did good. I didn't go to sleep. Yeah, they can ready to close this. That's what I'm saying. I want to see it. I have to do it when I come back. I can look at it, but I just can't. Wait, let me see how can I do it.
Judge of state believes it can complete
Hang on,
both
baby.
closings under a 2.5-hour time period.
2.5 hour,
Complete both.
2.5.
That's right.
How much time are you reserving for your rebuttal?
45 minutes.
That's a long time. Not the 45, but
It's a
2.5.
It's a lot of evidence, Your Honor.
Well, you gonna talk 45 minutes.
I'll say this, I'm not sure I've kept them sitting there longer. If I've kept them sitting there longer than an hour 45, it's been maybe once or twice. So you're pushing it an hour 45.
So I don't want to be up there an hour 45, Your Honor.
Well, I'm taking the math of 45, 2.5 minus 45 minutes is an hour 45.
We're viewing that as.
I know that right.
I believe we can accomplish those under a 2.5-hour time period.
Yeah, because I'm looking at my power, I have streamlined a lot and just trying to focus on
Okay.
certain points. Some things I'm not even talking about.
Ms. Michelle, Mr. Davis, is 2.5 hours sufficient for you guys? I say that because I give equal time. If I can charge them tonight, I will. They said they can stay later. And what I would do, and I think I mentioned this earlier if I didn't, is that I'll tell them on the front end, we're here as long as you want us to be here. If you guys want a break and want to come back tomorrow morning, we come back. The only issue is once I charge them, I'm dismissing the alternates. They've been great. We haven't had any issues. Hopefully the 12 come back tomorrow morning. Otherwise, we may have an issue and have one to call one of the alternates to come back. They'll still be under court order. I have instructions. I'll read them for the alternates to dismiss them, and my office will be in touch with them if we need a phase 2.
Well, y'all better go on to lunch then.
If I can charge them at 4:30, I'll do so.
And the state agrees, Your Honor. The court wants to inquire of them whether they want to have. You can tell them it'll take 20, 30 minutes to read if they want to have that read.
Do it at 4:30, then I'll be back home.
I don't anticipate, Judge, of the closings, but if we're running past 5, I do not anticipate that. But if it is, we all know that hour of the day how we observe.
No, if it's that point of the day, I can read the room. But if it's before then, if it's 4:30, even 4:15, 4:30-ish, no, if they agree that they can stay later today,
yeah, because they'll give me a chance to see it.
And I'll tell them on the front end, after I charge them, we are here as long as you want us to be here. If you guys want to go home and have a break and then come back tomorrow, you let us know. If you want us to order you dinner, I will order you dinner. Whatever you guys want, we will do.
Man, go on.
That way they don't feel any pressure.
I can't do him.
There's no time constraints. It's whatever they want.
We need Miss Cunningham on him.
And I'll be very clear about that, which I think I have been throughout the trial.
He playing around.
But I don't think we'll get to 5 o'clock. I mean, if we're starting at 12:15, and you may ask for 2.5, I have a feeling you're going to be a little less than that.
And tomorrow morning, you're planning on starting at 9, not earlier, right?
Correct. They said yesterday they can't start before 9, so I'm going to abide by that.
I just wanted to make sure.
How about we come back around 12:05? That's still an hour for lunch for everybody. Tidy up any issues we need to, and that way at 12:15 we'll be able to go straight into this. I appreciate you guys. I know it's been a long couple weeks.
Okay, y'all.
I'll see you guys back at 12:05.
All right, now, y'all. Let me put us on pause then. Okay. So there you have it, y'all. he trying to really get them. He not giving them a lesser charge, but he want them to give him a lesser charge. It'll be a lesser charge for him, but I don't know. But y'all, I guess we'll be back because I got to leave out at 12:30, and he said they'll be back around 12. What is it, 12ish? So I can see the trial, but I just can't post the trial. So I can come back. I can come back when when I come home, like I've been doing. Find the body one day. I want them to find it. He don't smash the body now. All right, Miss Lester, everybody. I appreciate everyone being here. And y'all did so good. You know what? Y'all can't believe I end up with grown people. I end up with people, all these women and men. Golly. Okay, y'all. Well, I'll see y'all later, but I will be back. We're going live on this. Yeah, they go here, auntie. They go her auntie right there. Look. Okay. All right, y'all. I'm out.